in the studio this morning is Gillian Opuni. He is Managing Director, Fidelity Bank. Also here in the studio is Ace Ankuma. He's a lawyer. Dr. Richmond Echiahene is Banking and Corporate Governance Consultant. Professor Eric Osei Sibe, Associate Professor, Department of Economics, University of Ghana, Senior Research Fellow, the IEA, and Head, Department of Distance Education at the University of Ghana. On the phone, we'll be joined by Dr. Theo Echampong, who is an economic consultant and political risk analyst, also a fellow of the Imani Africa. Gentlemen, good morning and welcome to Newsfile.
Good morning.
Right. I didn't hear all of you.
Good morning.
Right.
And Happy New Year to you and your children.
Many happy returns. Thank you very much. Okay, so we will not waste time at all. We will begin to look at the issues, but we're hoping that certainly for the majority of you, for Gillian, for Dr. Richmond as well, you are banking buyers. But we also want to look at the Menzgold crisis, look at that. If we can deal with that a little briefly first, and then, go into the banking matters and see how we can exhaustively deal with that matter. I was hoping that maybe today will be the last time we get to deal with that matter in the manner that we have done over the period. But Professor Dr. Richmond Echiahene tells me no, it's just the beginning. And I'll have a couple of questions for him in that area. So, if we can start this way. I want to begin to look at some of the issues that stick out as far as the Menzgold situation is concerned. Now, Prof, do you appreciate the model that Menzgold has operated? Do you find that there's a model so far?
Well, thank you. First of all, let me sympathize with the investors, the victims of Menzgold. If you listen to some of the stories, it's really heart-wrenching. It's heartbroken. I mean, after your hard-earned funds, expecting to make some yield to help yourself, if it ends up bad like that, it's really heartbroken. Right. But, I mean, I also want to say that as a people, we have to be a bit more careful, particularly when we are entering into any business venture. We have to take time to do more due diligence to making sure that whatever promise of interest that an investor or an agency promises you is coming from a credible source. Just because an investor, an agency says that he's paying you so much, sometimes sounds too big to be true. I mean, the fact that it's too good to be true, that is it. It means that it's likely that it may not come.
So yes. To what I say sticks out for me.
Right.
Can you design the module?
Yes, so the model...
That they take money from you and they give you as much as 10% or sometimes even more?
I mean, to tell you the truth, currently, I mean, across the globe, if there's any scheme really that promises to pay you an interest of 10% per month, that model, I can comfortably say that is a Ponzi scheme, which is way above the market average. 10% running into 120% annually. I'm just wondering what kind of investment that such an agency would do to make that returns. And therefore, when you look at the scheme, I mean, there was enough red flags to pinpoint that this is indeed a Ponzi scheme. I mean, if you look at the history of Ponzi schemes, right from 1920 when Charles Ponzi started, even before that we have Sarah House, who started in 1879, thereabout. You can see that they all share similar characteristics. And these characteristics often, they begin with some initial investment, and that investment, they entice people to invest in their commodities or securities and promises huge returns. Now, that returns, when you buy into it, they use your money that they have collected to entice further people, because they'll pay you juicy interest that will attract more people. Now, as more and more people join, they use the initial investment that they have gathered to pay returns for the new entrants. So it is not as if they have made any sales that they have made a return, but they are just robbing Peter to pay Paul. And so they are using the same investment that people had already made to pay newcomers, and that will continually actually entice more and more people to come. Now, let's look at this particular model. This model was using gold, right? People were made to go presumably gold. Yes, people were made to go to buy gold and then deposit the gold and get what they call the extra value. Now, Samson, gold is a bullion. Okay, gold is like a kind of medium of exchange or medium of payments, and therefore gold itself does not yield interest, neither does it pay dividend. The only way you can get any returns from gold is through sales. So the sales value, which you make some returns, either capital gain or you can make capital loss, because the price of gold fluctuates, very much. And so if any agency promises you a stable and consistent return from dealing in gold, I do not know where that returns is going to come from, because the only way you can make yield is when you sell the gold. And gold prices do not go up consistently. It goes down and comes down. And therefore, there's no way you can be guaranteed a consistent and stable returns from gold. And more so if you are being promised 10% per monthly. And therefore, people should have known that this really, there's enough red flag. It was clearly written on the wall that this is a kind of Ponzi scheme. Of course, people were enticed by the returns, but for us, portfolio theory would tell you, anything that would give you high yield is often associated with high risk. Risk, which is the uncertainty that you get the expected returns. So if they promise you higher expected returns, you should know that the risk associated with it is high. And therefore, that can easily happen. So I think that people should have known that this is too good to be true. And then two, the institutions itself, that is the regulator. I think the regulator, has acted, which is, for me, it is good. Okay. But it could have acted much...
Just hold on, because we'll deal with the regulatory aspect, and we'll deal with the regulatory aspect and ask the question whether or not there has been either what some say is regulatory inertia, or what others say bluntly is regulatory failure.
Right.
But I want to bring Ace on at this point, and Ace, I want you to help us understand how you understand the outcome of the matter that they had put before the court and which was dismissed this week. Because when things went bad and some of the customers went seeking refund of their principals, more particularly, they were told that because they had the suit in court, they were unable to proceed to make any payments until the suit has been determined. Now, clearly, it appears it has been determined. But help us understand what happened.
Well, the action was dismissed on a technical ground.
Okay.
You might recall that I was involved in the HFC matter, where the Supreme Court re-emphasized that if the law provides a procedure for ventilating your grievance, you stick to that procedure. Now, the defendants in this case were the Bank of Ghana and the SEC, the Securities and Exchange Commission.
Right.
The Bank of Ghana Act says that if you are challenging the exercise of the bank's powers under the Act, you go for mandatory arbitration.
Right.
As distinct, there's voluntary arbitration where the parties voluntarily agree to submit their disputes to an arbitrator. But if it's a dispute involving Bank of Ghana in the exercise of its regulatory powers, you go for what is called a mandatory arbitration. You have no option. You have no choice. You cannot file a writ in court. You must go for arbitration. And an arbitral award is, to all intents and purposes, it's almost like a judgment. Once the arbitrators give the award and you register the award in the court, you can enforce the arbitral award. And so it is possible that they can go for arbitration and Bank of Ghana will lose.
Okay.
Then there's an arbitral award that binds Bank of Ghana, and once it's registered in the courts by a simple by a very simple process, it carries the weight of a judgment of a high court and it's enforced as such. You can't appeal against an arbitral award.
Okay.
And so there's mandatory arbitration. And also, if your reliefs sound in public law, which means that it's not a private action between you and I for violating a contract, but you are saying particularly that a public body has not exercised its powers well, then there's another process. It's called the judicial review process, where the originating process is called an originating notice of motion, not a writ.
Okay.
And so, if you don't have to mention what is called the prerogative writ, that I'm asking for a certiorari right or prohibition or mandamus, etc., etc. But even if it is in the nature of them, so you could, for instance, go to court and seek declarations. Mm-hmm. But if the court says the nature of the declarations you are seeking sound in public law, and effectively what you're asking for is for the exercise of our powers of judicial review through issuing prerogative writs, then you cannot come to court with a writ of summons.
Okay.
You must come to court because a public law action. You must come to court by way of an originating notice of motion supported by an affidavit. And when it comes to with the SEC, the parallel is that if you complain about them in the exercise of their powers, you go before the hearing panel that is constituted, which can also make findings against the SEC itself. Okay. If you go to the NCA, they also have a panel. A lot of these regulatory bodies have quasi-judicial, or maybe it's even judicial, because it determines the rights of people who sit and hear and is regulated by law. If you go before the NCA panel, you appear before no meaner personality than Justice Dateba,
right,
who has given rulings against the NCA itself and some in favor of the NCA. And so this action which went to court was seeking declarations which really sounded in public law, and it was challenging the exercise of regulatory powers by the Bank of Ghana and SEC. Now, I think the first challenge to the Bank of Ghana's powers arising from these was in John Ofori versus Bank of Ghana and Ghana Commercial Bank. I was involved in that, where the court said exactly what I'm saying, that if you are challenging the exercise of these powers, under that there's 141 of Act 930, you cannot come to this court. You must go to mandatory arbitration. And if, however, your claim is in public law, and the court said you may come by originating notice of motion, but we'll look at it when you get there, because if you disguise it as a public law action, but what we are seeing is that you are really challenging the Bank of Ghana in the exercise of its powers, we may decide whether no, actually, still go for arbitration. But the court kind of left that hanging.
Okay.
And that is the same thing, the same principle that throughout the Tufo case.
Mm-hmm. Yeah.
Same principle. And it's the same principle that has thrown out the Menzgold case, that go to arbitration or go before the hearing panel. You can also decide to test it by coming by the public law action by an originating notice of motion, and the court will see whether this is really what it is, or it's simply a basic challenge that the law says ought to go before the panels. People could argue that the effect of these laws is that the people are being denied the right to court, and that under the Constitution you have a basic right to go to court, and the High Court has jurisdiction in all of these matters. These have been raised, and the Supreme Court has still said no. Once the law says this is the procedure you trigger to ventilate your complaint, that is what you have to do.
Okay.
So maybe somebody might be brave enough to want to test the Supreme Court again on this.
So what has happened? Where does it leave us, as in customers of Menzgold and Menzgold itself?
Well, this case, which was in court, had nothing to do with customers of Menzgold. This was Menzgold challenging the order of the SEC. Now, the SEC's order is very interesting. The SEC said, don't take any new deposits.
Right.
The SEC didn't say, don't pay your existing customers.
Correct.
Because if your business model does not depend on new customers, then pay the old people.
Right.
Whichever sales you claimed you were, which transactions you were doing in gold anywhere in the world. And it's very interesting that they claim to have been dealing in gold their license says buy from only small-scale miners. Small-scale mining had been banned for a year. So where were they getting the gold for? So if there's this gold, mythical gold, that is trading and bringing money on an exchange we do not know about, in a country we do not know about, and you refuse to submit your documents to the SEC to vet, to even decide whether your scheme can be licensed, then go ahead, pay the people, right? And so if your business is not robbing Peter to pay Paul, don't rob Peter, pay Paul. Now, if you can't pay Paul without robbing Peter, then you are a Ponzi. You are simply circulating funds, and that is an illegal investment scheme. So I think that the biggest test to whether or not this was a Ponzi for all of us out here is, were they able to pay Paul without robbing Peter? Now, also, all the Pauls who are unpaid, if your payments, now you are now seeing that your payment depended on robbing Peter, then sorry, you have the classic Ponzi, and the law has come down very hard on it.
Okay, now Gillian, we've heard repeated use of Ponzi scheme. What are we talking about? Of course, you are in banking, and you should understand these as well. What is it about? So that we are not only talking to Menzgold customers, but also potential Menzgold-like customers.
Thank you, and morning to your listeners as well. I think a lot of what you've just asked has kind of been referred to in the earlier submissions, because I think some people are aware of what constitutes the Ponzi scheme, and at this stage I don't want to veer into the point of saying this was a Ponzi or wasn't, because there's a lot more information that is required, but it appears to bear the hallmarks of that system where there isn't a fundamental business model, which is one of the questions that you asked. So you're attracting funds on the basis of promising a high return, normally out of kilter with what the fundamentals of whatever economy you're trading in is offering. And you rely on attracting more and more people to pay others. And if the majority of the people that are involved, or your clients, are comfortable with the concept of maybe just receiving their investment and not taking their original principal, then this can carry on for a certain amount of time until something happens and there's a stop. Referring to what Ace was saying, where as soon as there's a stop, then it means that your robbing model has changed significantly. Now that's different from standard banking, which is about financial intermediation, where what you are meant to be doing is you invest a certain amount of capital to create an infrastructure. And the infrastructure is meant to go to the part of the society that has an excess of resources and wants to deploy it in a certain way that they can get, an appreciable return, to those who also want to, improve their own economic standing or whatever it is. And so you are in the middle, and that's what banking and financial intermediation is. So you take from those with extra resources, you promise them the security of being able to repay them as and when they need it. You give them a return for what they've actually done, and then what you're doing is lending on to the other side, which gives them the ability to also improve their economic fortunes. So it's not that difficult to sustain a Ponzi scheme for upwards of 5 years? Depending on the infrastructure you put in place to attract more people. Now, with some Ponzi schemes, you can even create a lifestyle which attracts certain people. And people who even understand Ponzi schemes know that technically early entrants into Ponzi schemes tend to benefit. Yeah. The problem is you don't know when it ends. So if a Ponzi scheme has a life span of 10 years, those that probably enter 7, 8, 9, 10 may struggle. But day 1, day 2 may be okay. People who know something is a Ponzi scheme also normally work in their minds and say I have 100,000 cedis. I invest it in this. I work on the assumption that on a return of 10% a month, if I can safely keep my money there for 10 months, I've got my principal back. Everything that I earn after that is additional. Whether I get it or not is different. And that gets you to question whether certain people went in knowingly that there wasn't a fundamental business model. Okay, we have heard people who have said that they went to the banks, took a loan, and were intending to terminate their relationship after, say, 6 months. Of course, there were those who somehow forgot to terminate the relationship and kept enjoying until it went bust. Yeah. And that's a typical example of understand. If you went in for 6 months, then you knew that there wasn't a long-term sustainable business model that was going to carry on paying you. So you were going to, you knew the loan has to be paid back. The cost of the loan was obviously lower than the return that you were making on the investment. Right. So you're creaming off the margin, and you're doing it for a certain amount of time so you can walk away. So that appears to me to be, knowingly going into a scheme, understanding the potential impact. And it leads to the reason why I have a varied level of sympathy for some of the victims of this current process. I have, for some, almost zero sympathy, and for some, a high amount of sympathy. And I'll give you a few analogies to describe that. So there are some third-party, vulnerable parties who have been impacted by what is going on and an inability to get. So I'll give you a simple example. Say a retired teacher or civil servant has got a lump sum of money somewhere in a traditional bank, etc. A son, a daughter, hears about some investment scheme that enables you to get a higher return, comes to them. Now, this son or whatever it is a trusted advisor to this vulnerable party and says, take this money from the standard, please. I can get you on your 100,000 instead of the 12% that you're getting per annum, which is 1,000 cedis a month. It can become 10,000 cedis a month. That vulnerable party has not done any due diligence on where the investment is going, but is reliant on the trusted advisor being the son, etc., etc. Son goes, invests, and you're now in a position where the vulnerable party is out of pocket. And I have sympathy for those that were blindsided. Okay. For those that went in on some of the examples that you've given, where I went and take a loan because I know in 6 months it's come up, it's almost as if they were intending to quickly benefit and walk out. And therefore, the level of sympathy that I have is slightly reduced. Although in whatever instance, whether led by greed or ignorance or opportunistic approaches, etc., you still have to take the view that it's not right that people find themselves in a position where, for whatever reason, they are left out of pocket.
Interesting. Now, Doc, see, the manner in which he explains how it is possible to sustain such a scheme for quite a long time may be coming to some of the victims as new. Because if you're interacting with them, some of them, there is a huge number that only joined in later part of 2018, and then everything went bad. So for them, the way to determine that this was a viable business was that it kept touting that we have been here for upwards of 5 years. And there are people who have testimonies that we have been in this business for 5 years now. How does that go on without the regulator being able to see clearly and to stop it at the point that it ought to stop it?
Thank you very much. If you remember Benny Madoff operated this for 20 years, the Ponzi scheme in US, in the center of the stock exchange market in England, in the US, for 20 solid years. It was the 2009 bubble bust that actually exposed him. Other than that, he could have operated for 100 years. Even in the midst of American solid regulation. The reason being is that people call it regulative failure. I have a different view. In finance, we have what we call regulatory arbitrage, meaning that somebody places his investment in a market with where regulation is least intrusive or where there are no regulation. And this is, if I look at the man's model, this is exactly what he did. He looked at the right, Bank of Ghana is not in control, left, SEC is not, so he positioned himself in the middle. That is why often you hear that Bank of Ghana was making an announcement. Please don't take your deposit to them because they are not under my jurisdiction. Then SEC also made some announcement in 2016. So the guy, for me, anybody who is a Ponzi planner is a very intelligent person. Don't look down on them because Benny Madoff in America of all regulation operated for 20 years. So for me, once the chain hasn't got broken it could have gone on for years and months, years, and possibly centuries. Because it was not under the jurisdiction of SEC, neither. That is why we call it, I don't call it regulatory failure. Because if I don't license you, I don't regulate you. I can tell people, Bank of Ghana was only giving advice to tell people that don't go there. For us, we don't have anything to do with them. SEC say the same thing. But as I've heard from my senior people and the lawyers and the economists, you know, there's something in this world that when people are gullible and very greedy, once they hear about it, it happened in America. I always say that if it happened in America, those who went there, they were very also like those who have happiness here.
Okay. Just hold a minute for me, and I'll be going on the phone to speak to Dr. Theo Echampong. But Ace, when you hear comments like they were not, under the ambit of the Bank of Ghana and the Securities and Exchange Commission, what do you say?
I especially disagree. The Bank of Ghana is given the mandate to regulate banks and deposit taking, period. You cannot say that I am doing something in the nature of what Bank of Ghana is doing, but because I haven't applied for the license, I'm not regulated by Bank of Ghana. And Bank of Ghana cannot say that we can see that what they are doing breaches our law, but because they haven't applied for a license, we don't regulate them. I mean, that is a contradiction in terms. That is why the law says that if Bank of Ghana finds out that without their license, you are engaged in the business of taking deposits, they shut you down. You could go to jail. And so it is an offense to be engaged in deposit taking without the Bank of Ghana authorizing you through its license. And so for me, it's a dereliction of duty for any regulatory agency to say that this person is doing something that I should be regulating. I haven't regulated him or her, and so I am not in charge of regulating the person. What you do is that you shut it down. Same with SEC, and it was unfortunate that some of the communication from these regulators were contradictory. I don't know how much time I have on this, but we have to set this down carefully. First line, this is a private company. Basic rule in private company law, a private company cannot take deposits, cannot invite the public to either acquire its securities or bring in deposits. So the first line of defense should have been the Registrar General of Companies, the Registrar of Companies, because Section 255 gives the registrar the power that when the company is being used for an illegal purpose, for the registrar to step in, cause an inspection to be done on the company, go to court, and ultimately get an order winding up the business and recommending prosecution and paying back people compensations for what they've lost. So that is one line of regulatory failure. The company's registrar failed us by not stepping in and exercising its powers, triggering from Section 9 through 225 or 255. That was the first line. The second line was Bank of Ghana. And Ghana got involved in this after a second deputy governor said, what they are doing is illegal, but we don't have any evidence of it. That was in August 2017. So we started investigating this. And I can't disclose what we did, but it led us, we heard about all this gold thing. I said, how can you be selling gold and paying monthly dividend? It doesn't work. Of course, several people wouldn't listen. So we went to PMMC and said, what are they doing? We asked, what are they doing? We got the records. For the whole of 2016, they exported a value of roughly $3 million of gold. That's it. And so is it $3 million that's supporting this fantastic scheme? It's impossible. The monies they were paying out were way in excess of what they had earned. So is it unreported income? That's criminal. But how is it that they can sell the gold through PMMC and still be making money every month to pay people every month? That is not in the official records. So this is too fantastic to be real. So clearly, it wasn't the gold they were selling. And why were they selling that gold? They had been licensed in August 2016. Interesting date. August 2016. By Minerals Commission to buy gold from small-scale miners at their offices, at the company's offices, and then export. That was it. So they claim that we are not regulated by SEC or Bank of Ghana. We are regulated by Minerals Commission. It was farcical because the only power they had was to acquire gold from small-scale miners and export, not to sell locally. So when our letter went out, soon after our letter went out, in September 2017, the Minerals Commission wrote to them to say, we are sorry, but your power, the license we gave you, doesn't allow you to do what you're doing. So stop. They ignored it. And so when they said Minerals Commission was their regulator, Minerals Commission had written to them to say, you have to stop this. They refused, so they ignored Minerals Commission. What could Minerals Commission have done? Immediately triggered their Section 99 powers. It's a crime. Report to the police. Arrest. Jail. They didn't do it. Second level regulatory failure was Minerals Commission. Third was SEC. Okay, let's get to Bank of Ghana before SEC. This was deposit taking, and the second deputy governor at the time had given the hint. And previously, Bank of Ghana had issued notices warning people about dealing with Menzgold and other companies. What happened? Nothing. But if I'm engaged in illegal deposit taking and you have issued a Bank of Ghana notice, it should not end there. There should be that triggering of the criminal investigation and the muscle power to shut down, which Bank of Ghana doesn't have. And so, from the original conception of the deal, when the whole scheme was called Men's Bank and was doing deposit taking in Kaswa, Bank of Ghana went in 2014, saw it. The people reported it to to management of Bank of Ghana. They issued a notice. When they had a meeting and pointed out to them that they couldn't use the word bank, they went quickly and changed the K at the end of their name to C. That simply by changing your name, you change your character. Samson, if I call you Sam tomorrow, probably your legal obligations no longer exist. That's not the law. A change of name doesn't change your character. You are still what you are. And continue to trade. Then Bank of Ghana went in again and said, you still can't use it. And so if you notice, at the time they got the license from PMMC, both PMMC and Minerals Commission, they were called Men's Bank with a C. Once they got the license, then they took the whole BNC out and inserted gold. But even the so-called trade of gold that they were doing breached the licenses that both PMMC and Minerals Commission had given to them. So, but Bank of Ghana was clear that this was, whatever they've put on it, is just a sham. There's no real gold transaction going on here. This is an illegal deposit-taking scheme. Issued notices, had meetings with them. At some point, they threatened to take Bank of Ghana to court. That was just before they changed their name to gold.
Right. So that's the third level. Is there a fourth level with SEC?
No, but let's deal with Bank of Ghana.
Okay.
When the people in the Bank of Ghana did this job and sent it to the governorship, they did nothing. So at the time the second deputy governor was saying we don't have evidence, I know that they had evidence that the people were doing illegal deposit taking. Why didn't they stop them? The fourth level quickly is the SEC. What they had tried to create was a crude form of a derivative, which should be regulated by SEC. It's a very crude form. And if you look at the SEC Act, both PNDC Law 333 and Act 929, it covered it. So to have read in the press, to extent that it's true, that an official of SEC had said, we are not sure they fall under our regulation, was the fourth level failure. Finally, SEC realized that they had the power and they moved in. Unfortunately, the SEC law doesn't necessarily make the illegal derivative an offense. What they do is that you have an administrative penalty, which is up to 4,000 penalty units times 12. 48,000 series. Okay, that's one. If they then close you down and you continue to operate, then it becomes an offense. Right. So there are 4 levels of failure where each of these regulatory bodies could have stepped in to stop it, and then maybe later we'll come to the customers and the nature of the contracts they sign. Right. We must open that contract up to Ghanaians to see.
But I'm also interested in whether or not there is some form of liability. Because if you have identified these failures, can the customers have any claim, as in against what has happened, as in against government, so to speak? So hold on briefly. Okay. Yes, Doc, I'm coming. Let me go to the phone lines and speak to Dr. Theo Echampong. Thank you very much for joining us, Theo.
Yes, good morning.
Yes, good to have you. Okay, so From where you are, we understand that many Ghanaians who live abroad in England and perhaps maybe where you are, you're in Aberdeen, correct?
Yes.
Great. Appear to have also taken money from where pounds came to Ghana, put it in Menzgold, and now have lost. A good number of them have a counsel in Amanda Clinton, who has also been waging the war towards seeing whether they can get any monies for them. From your analysis of the situation, do you think that these victims or customers will get any money? There is any money that's available for any of them?
That's interesting. I think no. No for a number of reasons, and I'll come back to it briefly. But I think the Menzgold saga actually is symptomatic of a number of things. One, in the sense that we're in an era where there's relatively high financial liberalization, but low financial literacy. So in one sense, the market is growing, the economy is changed, and you have sophistication in terms of the financial products that are ordinarily available to people. And coupled with that, the barrier between finance, technology, and people has increasingly become smaller, which then means that a lot of these sophisticated alternative investment schemes are likely to abound and actually are going nowhere. But in that same breath, you actually are increasingly seeing that many people actually don't understand the concept of risk. And coupled to that, you have weak regulations or regulatory laxity, which ACE actually has gone into quite a lot of detail. So it's not too surprising to see how this cocktail of issues from having liberalization of the financial sector and having very low financial literacy coupled with the regulations can create that perfect storm where Ponzi schemes like Menzgold can actually thrive. And to go back to just a little bit on the literacy aspect, which I found very interesting, and I'll link that to the question you asked me about people from outside also investing in it. You can actually see that it's all well and good to actually blame the people who invested as being greedy. But the more fundamental issue which is at stake, I think, is how we understand, risk. And I'll give you a couple of examples. You can see that a lot of the people who invested in Menzgold and most of these alternative schemes actually are not poor. They are people who come from the middle class in Ghana. And when you look at the Ghana Statistical Services Labor Force Report for 2017, the average monthly earning in cash and in kind for most Ghanaians is about 1,250 Ghana cedis, which roughly translates into about $10, a day. That would correspond to the global, benchmark of what qualifies as somebody who is living, in the middle class. To understand the risk, you need to decouple it into a number of things. One, which is the concept of, interest. So most people who invested in Menzgold would tell you that, we invested because the interest was quite juicy, and they were offering them 10 whatever percent, month on month. And at the same time, people understand kind of inflation, in a sense. But when it comes to risk diversification, which is, the other aspect of financial literacy, which is to say, do you understand fundamentally what you are investing into, this so-called gold collectibles and gold trading, business? Because that's actually a higher risk, class of assets. And do you actually, or can you ask the basic questions about how the company operates, what is its business model, how are they making, money out of that? Most people actually did not, undertake that or did not understand what it actually means by risk. And as some of the earlier panelists have said, for every risk there's a return, or for every return there's a risk. So the higher the returns, the higher the risks are going to be. So for me, it wasn't too surprising to see that people from the middle class in Ghana, and of course, people also, Ghanaians based outside, were using their own monies or sometimes even borrowing. I know personally of people who invested, anywhere for anything from 10,000 Ghana cedis to 100,000 Ghana cedis, in Menzgold, with the expectation that, they would make a quick return and then basically, to get their principal back. And like most of these, Ponzi schemes have operated since time immemorial. Once there's not a systemic shock to its operating model, they can continue going on. But at the moment something external comes in, and in this case, it was part, I think, with a statement that came from the SEC, although it came in relatively, a bit late, which said that, well, of course, you have a license to do a number of things from the Minerals Commission, which is to buy gold and then export. But we are not too sure that the investment part of the business that you are engaged in is actually, is actually legal. In that sense, don't continue doing that. However, we don't stop you from, paying those other people who have already invested in. That was the big, external shock that came in, which, basically led to a collapse of the business model because they could not sustain, payments or the extra value, they call it, to the so-called individuals. So quite a number of people invested in it, and it's even shocking that, the statement that came from the finance minister that, enlightened and prominent Ghanaians put their money in Menzgold. And that actually included people or staff at the Ministry of Finance, but also people from Bank of Ghana, including military personnel. And this is a statement that is being attributed to the finance.
Well, interestingly, some had put church money and NGO money all in there. Now they are all confessing that. But Doc, you hold on for me. I'll come back to you. I want to bring in Dr. Sesibe here at this point and ask the question. You were moving to the questions of regulatory failure when I brought in ACE. So it does appear that ACE has done such a clear, explanation in identifying the lines of fault as far as regulation is concerned. Now, guess what? When I was asking ACE what the people could have against these entities, including us in the government, I was interested in referring to Section 123. And Daniel Dazi has been referring to this a lot on the morning show. It is important that we pay attention that when the Commission has come to the conclusion that someone is doing business that they don't have power to do, it has the power to issue private warnings. It could issue public warnings, among others. But in this section, subsection 2, it says that where the Commission is satisfied that a person has obtained monies without a license or contrary to the terms of the license of the person, the Commission shall in writing instruct that person to A, repay all the monies obtained and the profits accruing to that person. B, return assets acquired as a result of the illegally obtained monies or deposits. Or C, pay any interest or other amounts which may be owed by that person in respect of those monies to the respective persons from whom the monies were obtained. Are the customers right somewhat when they say until and unless the action that was taken by the SEC in the manner it did, they were still enjoying their benefits anyway, and that they ought to explain to them, they are liable to them?
Well, while I think that there has been some regulatory sloppiness and inertia as far as the Menzgold issue is concerned, I do not subscribe to the viewpoint that any of these regulatory institutions have any obligation towards the customers. I mean, from the history of Ponzi scheme or any offset scheme running over, which is more than a century old, there has not been any single example where a failure of a scheme has led to a regulatory authority or government actually coming out to bail out or to compensate victims. I'm yet to see any example anywhere, because, like I said, well, it's a choice. You know, you have a choice. The government or the regulator did not put any pressure on you to actually invest here or invest there, particularly where it has not been licensed by them. If it has been licensed and there has been an approval, yes, then it means that they actually sat back for this to happen, and therefore they bear some kind of responsibility. But in this case, the only way we can actually fault the regulator is the fact that it did not move in early enough, you know, to nip it in the bud. I mean, to bring it down early. And so I think that we cannot really hold any regulator responsible. I mean, the best that it can happen for me, as painful as it is for the managers of the fund to be arrested and surcharged. Now, even if they are not arrested, they are now at large. What the government can do is immediately put a freeze on all its assets, the assets that it have, particularly, and then maybe appoint a receiver. The receiver then comes in to liquidate whatever assets that are available and see whether, you know, it will be able to salvage something, you know, and give to the victims. For me, that should be the only way out. There shouldn't be any occasion where central government or central bank or SEC should bear any responsibility or use any taxpayer funds to bail out. It has never happened, and I don't think we should allow that to happen.
Since Julian has a certain level of, you know, gradation of sympathy, at a 0 point and at some point some amount of sympathy for some of the victims, do you buy this kind of approach, which endorses the government's outlook that not a penny of the taxpayers' money will be wasted, will be spent?
I think I agree with the submission about whether taxpayers' money or central government funds should be used, because the sympathy for the people does not necessarily translate into an action to take responsibility for repaying those people. And we need to be clear around that. And so what I would say is, if there's further action that can be taken to assist the process of reducing the damage for these people, regardless of the level of sympathy I have for them, that I would urge all the authorities to do as much as they can to ensure that, you know, examples are what we're given. If you put into receivership, try and liquidate what is there. Now, I am not certain of what level of assets, because there's not been a real assessment of the assets of this organization at the moment. And so, not to give too much hope, if it was or is a Ponzi scheme, and I keep saying if it was or is because I think that will be proved eventually, then it's likely that the hallmarks are a lot of the assets are not necessarily fixed assets that you can touch. So normally there'll be lots of leased properties, leased vehicles, etc., and the core of the funds are used for other purposes, some to repay people's investments and others to satisfy their own lifestyle needs of the organization. And again, it's required to create the semblance of an organization that is growing to keep a Ponzi scheme going for a long time. So you have to have a presence on high streets, keep growing, get bigger and bigger, and have a large footprint without necessarily investing in fixed assets that you can't liquidate quickly, if that is what it is. So I think the sympathy cannot be translated to an expectation for government to take the responsibility of actually physically repaying these. However, there's for the purposes of making sure that this doesn't happen again in the future, we have to come down hard to ensure that all that can be done to recover is actually done.
All of you here seem to be agreeing to this point, but Dr. Chani, is it not problematic when, for example, I just read the law to you, and that the customers may have a point that until you did what you did, there was not a run on the company. As far as they are concerned, what you did caused a run on the company, and that's why you are unable to pay us. In any case, when you were going to do that, you had all the power in law to ensure that our deposits had been preserved so that you would take that money and give us. You had the power in law to ensure that their assets were taken control of. So, why?
If I heard what he said that the notice to them was to stop, not to stop Paul. What was there should have been paid. It's a very simple analogy. I think they didn't say that keep that money you have, don't pay. So for me, that is neither here nor there. I stand by what Professor Sesibe has said. I mean, when Method, I use Method, 17.5 billion lost in American market. It is here. NASDAQ.
Yeah.
NASDAQ. I never heard anywhere that NASDAQ were called to pay to those people. Nowhere. So I want a precedent. Maybe they are the lawyers who will tell me that it's been done in other jurisdiction. But as far as I'm concerned, 2008, immediately the financial crisis came, people started making demand. That was the end of the genesis of the Exodus. And nobody, no institution paid. You go to take risk, and you have taken a risk. When you took the returns, I'm sure you never came to Sami, take 5 cedis. Now you want us to collect our taxpayer money to pay you. We sympathize with them. As Ace said, look, there was sort of poor coordination, poor information sharing. Because if you have read the Bank of Ghana law, even the recent corporate governance, they tell you that they don't have the power to prosecute you, if I'm right. They will recommend. Maybe what we can now do is that they must be up and doing. And it also stems from the type of regulatory system we have. Anytime you operate the multi-regulatory system, you're going to have this challenge. So I think that is why you heard them recently, they're talking about Financial Stability Council, bringing the regulators together. That is only a tip of an iceberg. They must begin to look at what the South African has done, the Kenyans. You have a new set of regulatory system, like the Twin Peak approach. And at the back of it, you have Financial Stability Council.
Okay, so here, Ace, you clearly point out 4 clear levels of, failure. How there's a fifth? How is this not a shaking of responsibility for which there ought to be some duty or responsibility to those who are suffering now?
There's a fifth, and the fifth is the people who are invested with the political muscle to cause arrests. It is shocking to accept that Bank of Ghana can issue a notice and list 7, 8, 9, 10 institutions that are breaking the law, and there's no direct link to the CID or the economic and to IOCO to immediately go in, shut them down, arrest the people, prosecute them.
That's right.
That is shocking. And so that is the fifth level of failure. The failure to link these institutions up with the police and you know what some police people said? We are waiting for an official complaint. All right, going forward, can we have a system where Bank of Ghana back to back or any of these institutions, when they find that it involves crime, will immediately send a copy of their notice to IOCO or CID or FIC, so that steps are taken to stop these once and for all. That is a fifth level of failure. Now you see, you can go to court tomorrow. and say that you want declarations that these institutions failed, I think you will win. But will you get any money? I don't think so. Because you ought to be able to establish that there's a cause of action which gives you an entitlement to taxpayer funds. Look, these monies are not going to come out of the pockets of the individuals who fail to act. In other words, you're saying that you and I, the people who didn't involve ourselves in this, should pay for your either naivety or greed. And that means too. You are either naive or you are greedy. And we can't feed that with state funds. Now, you see, and that argument shocks me, that they should use state funds to pay you. It means that you have no concept of what state funds are. Some of these people probably haven't paid taxes before. Yes. Because if you pay taxes, you cannot agree that your tax monies should be used to pay somebody to fund somebody's naivety or greed. And so that is a fifth level of failure, Samson. The shit. But let's get the facts in right. That the gentleman was invited by Iyoko and granted self-recognizance bail. That's what people don't realize. In August of 2018. And he was supposed to report, I think, every week. He reported 3 times and stopped. And then they couldn't find him. So maybe this disappearance we're talking about didn't just happen recently. Right? So now the CID move to get the warrant was based on finally customers making complaints to the CID. That's shocking. So all of this time, customers were still sitting down, hoping their monies will come. They only just realized the monies were not going to come. And so they started trooping to the CID to make complaints. Then CID started looking for him, couldn't find him, and then went for that warrant. But I know that Iyoko also has a warrant for his arrest. And Iyoko's investigations had to do with the illegal deposit taking. So he will face multiple agencies. And if he's listening, look, please come. Right? Because the longer you stay, now the court might consider you a flight risk. So the prospect of bail no longer exists. So,
but can we also answer the question, whoever it is that processed him took his statement and decided that he was amenable to be granted bail and gave him self-recognizance, and Ace, you will explain that to us, meaning practically he didn't have to part with anything and no security. We are told he breached his bail conditions. What were they?
Well, self-recognizance, and how do I break it down? Bail basically says that I assure you that I will attend further events. I'll attend these investigations. And if you are not a person of means, then another person has to stand in as a surety to say, if he doesn't come, hold me responsible. Now, if it is done with what was the term again?
Self-recognizance.
Self-recognizance. They look at you and say, you have sufficient means, and we don't think that you are a flight risk.
But in addition to that, when they are doing self-recognizance for public figures like he was or he is, they would often ask for your passport or some travel documents and seize them.
I agree. That if they considered him a flight risk, they should have seized or that you seek permission before you travel. It's as if, I think at the time, they felt that he has sufficient business interests not to flee. We don't really know if he's fled. Who knows? Maybe he's on his way. He's on the next flight to Accra. But yes, we can now do Monday morning quarterbacking and pick at what they should have done and what they should not have done. But I think that there's enough. Finally, after all these years of pussyfooting around the issue, there seems to be a firm decision that we need to bring this.
Okay, it sounds
and
to
it's
me.
Not just him.
It sounds to me somebody didn't do their job well in this regard.
Yeah, you're probably right. Now, several stages. And what I presented to you is not somebody. This was a colossal failure of the state. Colossal failure of the state.
And we say that is okay. All of those who have failed, that's okay.
No, but that's what we're talking about. We get to the banking sector. We basically we fail ourselves, and nobody gets punished, nobody gets hurt, and we go into the next bout of failure. The problems we are seeing with Menzgold is the same problem that has led to the collapse of the banking sector. Forget about all these nice words about capital adequacy. No. The people tasked with doing the work, let me repeat this, went to sleep. They opened the gates and went to sleep. At every stage. No, look, you should, I don't know, the Bank of Ghana's officials were telling their bosses, let's shut them down. Legal department, let's do something. nothing was happening, then they would issue one statement or they would issue a warning letter.
So eventually we get to start to do something.
Yes.
And then we arrest him. Basically, that's what happened. Because if you have to be granted bail, it means you practically have been arrested.
Yes, you've been arrested. Yeah,
we arrest him, and we don't put him before any court. We feel he's entitled to bail, and we don't take sufficient conditions. And now we are here saying we need a warrant.
Yeah, but see did you see the abject confusion even in the minds of the regulators as to whether or not their laws have been breached? Now, if the regulator is not sure that its law has been breached, who is the policeman to put him before court? So that confusion, is what probably led to them. Okay, let's give him some reconnaissance bill. Let's continue to investigate. Let's get the body of document. But look, you are right that we are actually trying to shut the stable door after the horse has bolted. Now, I have a very interesting version of that for Ghana. In Ghana, if you say you shut the stable door after the horses have bolted, normally it means that you are trying to do something after the situation has gotten bad. In Ghana, the horse is actually in the stable. We'll go to the horse and ask the horse to get out. When it refuses, we'll try and lure it with food. When it refuses, we'll beat the horse to leave the stable and then close the stable door and say, yes, we shut the door after the horse has bolted. We had every opportunity to stop this thing in 2014. We did not. We had every opportunity to stop this thing last year. We either failed to do it, neglected to do it, or refused to do it. Now suddenly there's a groundswell and everybody's woken up because now it's beginning to hit everyone. Now people are beginning to post pictures. They may not mean anything, but they are suddenly claiming that, well, because I saw this picture, I invested. It's nonsense, really. But suddenly the public officials have woken up to the fact that they have to act. So maybe if he arrives back in Ghana, the proper thing will be done. But
and still looking at the legal side and a bit of the failures that you have identified, the warrant, it does appear there are problems with it. So that it may be so defective, it's invalid. And all this noise about the fact that he's on Interpol alert is actually just false.
No, it's not. My quick response is that we need to train so many lawyers that the press houses can have in-house lawyers who can speak to this very quickly, so that the press house doesn't send journalists chasing the wrong court and filing reports which appear technically true but has no basis. Yet, yes, the warrant had two issues. One, it mentioned the Supreme Court when the warrant has actually been issued by the Circuit Court. But the stamp and signature of the judge under it was the Circuit Court judge. Now, and then two, it mentions the name of the president. Let me deal with the issue of the president first. You would recall that in Chashishikata number 1, the summons to court had been issued in the name of the president. In number 1, the Supreme Court, by a majority decision, held that since the president was wasn't the person with the power, it was an unconstitutional demand, and so they struck out the summons. Right, the majority decision. Interesting decision by Justice Atugba in his dissent says, yeah, I have a problem with it, but they should just have amended it. They can just be asked to amend it, right? But in Chikata number 2, the Supreme Court completely set aside the decision of the Supreme Court in Chikata number 1, which meant that they didn't consider it an issue. So I'm still shocked that we still have court documents of like warrants still bearing the name of the president. And you can't say it's a 1960 document. It can't be. Actually, it can't be 1960. Because if you look at the date, it starts with 20 and leaves a space. So it is after 2000. Right?
It's a reproduction of a 1960 document.
Yes, but we should be smarter. 2, if you look at the law on warrants to arrest, and if you look at particularly the second schedule, and it's this section 70 something. The essential elements are the signature of the judge, the statement of the offense, and the instruction to the police to arrest. And so, in terms of its essential ingredients, it exists. And the law, Act 30, says that you are allowed to do what lawyers call mutatis mutandis amendments. So, all they should have done was to put X's across the word supreme and tied circuit and like we do for the writs of summons.
Right.
That was all that should have happened.
Right.
So there was some clerical laziness where they should just have drawn 2 lines across the word supreme, written court on it. It ties in with the signature of the judge.
Okay.
Take the word president out, write republic on it, and then so it's 2 words.
Yeah.
So to me, it's sloppy. it created a fair bit of uncertainty out there.
Yeah.
But it is essentially a warrant which will be effected. And another thing, Interpol is not alerted before the warrant. The warrant must first be issued before Interpol. So go on the Interpol website and say the thing is not the Interpol website. The thing has probably not even left Ghana to Interpol yet. Yeah. So I mean, people were, and it was good that people were doing good checks.
It's once the warrant is procured, the police have a process. They would now, transmit it to the Interpol department
in Accra. Accra will then upload it to the Interpol International. They have to then determine which are the possible target countries.
I've had to deal with one very recently, like 3 weeks ago. And it didn't occur to me that the Interpol and the police require up to 48 hours to be able to ensure that it gets to Interpol.
Yes, there's a time.
So
lag.
what's happening?
Well, my understanding is that once the warrant is issued, it goes to the local Interpol office, who then must upload it through their processes to the worldwide office. Then and they have to determine which are the possible countries. That because if I'm sitting in Australia, I'm not going to look at it. But we said, okay, Kenya, we suspect that he must have entered your system. And now that all passports are actually scanned, you have to identify the core countries for them to check with their immigration system. And sometimes they will not upload it because some of the information is being done quietly. And so do not expect that immediately you go onto the Interpol website, you are going to see it. They would sometimes want to do it first and then see which levels of escalation that we've done the core countries. It's time to go to the secondary countries, etc., etc. There's a process. Things just don't happen. So I can understand that there was a fair bit of public uncertainty, but I haven't seen the system work. I think that let's give it about another week.
Okay. Now, I've interacted with ACE for quite a while. I want to go to Dr. Theo Echampong, but ACE will assist us once again. He appears to have agreed with Theo Echampong that, look, they are chasing after the wind, as in the customers. There's practically nothing for them, and so they may as well just give up. I want to ask Theo, what gives you, that kind of confidence?
Something, can you please restate it?
Yes, you seem to be very certain that there's no money. They may as well just forget about all of this and go to sleep. What gives you that confidence?
No, I think the money is gone, and it's quite, for me, it's going to be very difficult, to get any payment from Menzgold whatsoever. But more so, I don't think it is the remit of, the government, to reimburse or to repay the people who invested. Because, we cannot socialize the cost whilst, the profits are being privatized in that sense of the word. So I just cannot see for the life of me how they're going to get their monies back. But perhaps what they could do, which is, within the legal remit or mandate is to launch a couple of class action lawsuits, against Menzgold, its principal shareholders and directors to see if they can recover, some of the money that they would have invested in the company. But other than using the legal processes to recover their money, I cannot for the life of me see how they're going to get those monies back. So it's pretty much, somewhat a lost cost, beside the legal processes that can be adopted. But just touching briefly on the regulatory issues, I think yes, to a large extent there were significant, regulatory failures, and coupled on top of that, there was, very weak consumer protection by all the institutions that were involved. So from the Register of Companies to the Bank of Ghana to the SEC. They were all, to a large extent, complicit or derelict, in carrying out their duties by not being proactive enough to, go in and shut the company down when the issues, cropped up. And you may ask me, why is this the case? It's the case because when you look at the fundamental principles of, financial regulation, one of the key things is that any financial institution that is subject to systemic risk, and this is not only banks, but also interconnected financial players like insurance, insurance companies, securities companies, trading houses, you name it, they must, be regulated, and they must be covered by regulation. So their legal identity, whether they're a bank or an insurance company or an exchange trading house, doesn't really matter. To the extent that they pose a systemic risk to the financial industry, they must be regulated. So for me, it wasn't enough for the Bank of Ghana or the SEC, for that matter, to just come out and say, these companies don't have a license and they are not covered by us, therefore we cannot go in there and shut them down or ask the right questions. What they should have rather asked themselves was, did these companies or did their actions pose or fall within the range of their regulatory remit authority, to the extent that they can pose a systemic risk to the whole financial industry. And if that was a yes, then they should have been proactive to actually go in there and cut their tails off at a much earlier stage. That came in 4 or 5 years down the line, when a lot of money had gone down the drain. So going forward, I think yes, the regulators should be up and doing and a lot much proactive in some of in picking up on some of the information. For the investors themselves, yes, they should utilize the legal processes and possibly think about launching a class action lawsuit. What the government could possibly do for them, maybe provide some sort of pro bono legal advice to help them use the processes to recover their money. But the last point I just want to touch on briefly is on the question of financial literacy and financial education. I don't know if you've ever heard about the Investigation and Consumer Reporting Office, ICRO. This is an office that actually sits within the Banking Supervision Department of the Bank of Ghana. And it's actually, when you go on the Bank of Ghana's website on this department, it says that it is, quote, the financial industry watchdog of the Office of the Bank of Ghana, with a responsibility for protecting consumers of financial products and services and educating them on their rights and responsibilities. And I was just asking myself, so where has this office been all this while? And where has where has also the joined up thinking been in terms of educating people, particularly the middle class, not just the poor people, the middle class, on understanding the products that they are investing into, understanding the risks that come with them, but also providing an avenue for some sort of ombudsman where they can actually go to resolve their issues. So we need more joined up thinking at the institutional level between Bank of Ghana, NCC, the telcos, the fintech firms, and the banks themselves, to protect consumers.
Thank you very much, Dr. Theo Echampong there joining us far away in Aberdeen. Now, I'm back in the studio, and forgive me, but I need to focus just a bit more on Ace. He's talking about that he feels that their last resort could be to the court and through class actions. Earlier, you were suggesting maybe we should look more into the contracts that they signed. I don't know, but forgive me, I seem to have gotten to know that your firm is one of those that is not interested in doing some of these cases. What would you advise? Is it good to do a case for them?
I won't speak about my firm, but there were reasons, possible ethical conflict reasons, and that why we. But what I've done is that when these cases have come, I've called friend lawyers and say, "Can you take this case? Can you take this case?" I haven't communicated that my firm won't do it, but
forgive me.
Quite a few have come our way, and I've referred it to other learned friends, to handle that, to the extent that we are learned to handle. Look, you could file a class action, but we have to get to the documents they signed. When I finally got to see it, let me say that friends of mine who had put money there consistently refused to let me see the agreements they had signed. I said, "Can I see what you signed?" Now, a friend says, there's a saying that before you invest, investigate. Before you invest, investigate. What is the nature of the document you are signing? Now, you want to go to court now. You sign a document that says that all proceedings will be under the laws of Ghana, but any dispute shall be settled by arbitration as directed by the Arbitrations Act. Then it puts in bracket at ... brackets close. There's nothing like Arbitrations Act in Ghana. We had an Arbitration Act that was repealed in 2010 and replaced by the Alternative Dispute Resolution Act. So if you are signing an agreement in 2016, 2017, that is referring to Arbitrations Acts. There's nothing like that. So which arbitration act were they referring to? Is this a valid arbitration agreement? But the next clause is what is more interesting. What they say, a joint declaration. That the company and the trader declare to each other and to one another that the gold offered herein for trade and origin and funds used in paying returns on the gold trade do not contravene, and they list a certain number of acts. The Drug Trafficking Offences Act of 1986, Criminal Act of 1988, Prevention of Terrorism, Temporary whatever of 1989, Criminal Justice International Cooperation Act 1990. Can you just Google these? Well, I did. And what did I find out? One, none of these is Ghana law. Okay. A number of them are from the UK. About 2 or 3 of them have been repealed already. Had nothing to do with gold trading. One had to do with the UK criminal procedure law. It's procedure law. It has nothing to do with it. Basically, they just went out, found nice sounding laws, put it in the agreement. People might have read and say, oh wow, we are protected under these laws, including the US Patriot Act, which was passed to be an anti-terrorism. Now, and so you sign this.
People have acts, Ace. People have acts that it must have been a lawyer who drafted this for them.
I'm shocked.
The legal profession in Ghana is regulated.
I'll be shocked if it's a lawyer who drafted it.
Okay.
I'll be shocked.
So if it's a lawyer, they'll be punished.
They could be.
Okay.
They could be. And indeed, if the police pushed racketeering charges, that this agreement was deliberately put in place to trick people, then whoever had a hand into drafting this could get into trouble. But there's one that is even more graphic. When they talk about the metal that has been traded, they called it aurum utalum. The contract you signed said you are trading aurum utalum. Now, basic O-level chemistry, the gold is AU, but it is not aurum utalum. Just Google aurum utalum. It is a nickname for fool's gold. There's no word utalum in Latin. It is for fool's gold, fake gold. That is basically. Do you remember also that Abyssinia? Abyssinia. Yeah. Yes, it is a nickname. So you sign an agreement which you agreed that the metal you are trading is fool's gold.
Are you saying by the nature of the contract itself, they have nothing to hang on to?
I think that they could go for a class action. There are certain thoughts that the thoughts of deceit. There are certain French thoughts that they may want to push in to get an action back. But look, court is interesting. It's only worth your while if you want to vindicate a principle or there's money to be gone after. Civil action. If there's no property, you'll be throwing good money after bad. And so you pay lawyers, they go to court and get you a fine judgment, but what are you going to enforce against? Does he have any assets? Are the rumors that all the buildings and cars were rented? So what is your recourse? Against what are you going to execute? And the time, we still don't know, we still don't have a list of assets of customers or what the liabilities are, because they refused to submit the books to SEC and went to court. And it was only 2 days ago that the court threw the action now. So guess what? This is the first time that SEC is going to have access to the books. Have hard drives been bleached and blanked? Were they doing cloud computing?
There's someone who took up a suit in the Ashanti region in Kumasi, and he did it at the circuit court, which supposes that the money was not more than 50,000, correct?
Yes.
And they were supposed to levy the judgment against a property. We are told that there is an interpleader action. What does that mean?
Interpleader simply means that the person, you assume that this person owns property. You have judgment against him. You want to execute against that property. And I show up and say, guess what? He doesn't own the property. He's probably just a tenant. Or this is really my house. So the interpleader is the one who comes. The pleader summons issued by actually it's the sheriff who interpleads, but talks about there's a claimant. There's a claimant who says the building is mine. And so the court will try the issue. And if the claimant shows that I own the building. He takes the building away. You have nothing. In fact, sometimes if you execute wrongly, you pay him costs for wasting his time for him to come to court. And so if this gentleman planned his affairs well and just leaves all of these probably on monthly basis, you have nothing. And if you don't identify an asset, going to court in a civil action is just to make you happy that you won. But when it gets to the real meat, there's nothing. So unless you can identify his property, people are talking about his relatives' property, wife's property. It becomes iffy unless you can show that really there was an attempt to hide property. You're going to get into tracing and equity. It's not going to be an easy fight, right? But I still think they should fight. I'm not sure it's going to be an easy fight, but they should fight. They should hit the court. I'm not too sure that arbitration is the process to go right now.
There are also those who are hopeful that the criminal process that has been triggered will eventually get monies and then they'll be paid.
Criminal processes do not automatically lead to money. If he's a criminal, he's going to jail. If the court makes a restitution order, that is fine. But it makes a restitution order, you must enforce it like a civil judgment. So you enter the judgment and then you try and enforce it the same way we're talking about. And if he doesn't have the property, you still can't execute the restitution order. So they have an uphill task. I wish them well. I wish them and their lawyers well.
Okay, Gillian, so what's your advice to the customers and those who may find themselves in such a potential situation so that they don't get themselves into that point in the first place?
I think there's some fundamental basics of anything that's too good to be true really is. And there's been questions around financial literacy, and I think we all, especially us in the financial sector, the media, everybody has a bit of a responsibility with regards to impacting positively on letting people understand some of the risk that they're going into when they're getting involved in schemes like this. That's the only way we can help it. Obviously, with the level of education in Ghana and the opportunistic bit, no one can be educated out of greed. But that's just the fundamentals of what the human nature is like. So I think I would say we all have a bit of work to do around the financial literacy, letting people understand the fundamental basics of this and ensure that this doesn't happen. Unfortunately, we as humans, and even in Ghana, we have short memories. So I don't know when something like this will rear its head again. Hopefully not again.
Well, it does appear, I hear, that there are other entities who are almost in the same nature already in the system. Mm-hmm. Doc, what's your advice?
My advice is that, as Dr. Champon said, there is a need for awareness, education. But unfortunately, the institutions that are supposed to sponsor and to help the education, they will sit back. I believe that the regulators, the banks, the institutions should begin to invest in it. Because apart from all these things that we are saying, they are about reputational risk. It also put confidence level low in Ghana. So those in affairs must, as he said, public education. It's not just happening in your office saying that you have an education office. They must go down. And when it happened at DKM Sunyai, I'm not sure anybody has been there to tell them about this investment. There was a lady at Volta region who had to put money in plastic when the bets went there. So I believe that education, awareness creation, and also strengthen our regulatory frameworks. ACE has analyzed a lot of things. There are lapses and regulatory overlaps. And we seem not to. We set institutions and we forget. Recently, we've set the coordination, financial stability coordination. We need to do more than that. Okay. Because this information, if Bank of Ghana has taken this, we even informed the police that these guys were doing illegal things. I believe today, we won't have what we have. SEC also did the same thing. They have the information. They won't want to sit back. I mean, we must be proactive, as Dr. Champon said. We have a lame duck attitude in regulation.
Thank you. Now, Prof, what's your advice?
Well, let me just give me one chance to go into the Bank and Specialized Deposit Taking Institution Act 2016, that is Act 930. Now, where it talks about deposit taking business. Now, in Section 4, Subsection 5, it actually says that for the purpose of this Act, deposit taking business means business of taking money on deposit and making loans or other advances of money. Now, the word there, money is not only the paper notes, in a strictest sense. Money, as we know, is anything that can be used as a medium of exchange or as a medium of payments, right? Now, so money can be used, anything that can also be used as a store of value or means of deferred payment. So if you look at the evolution of money, it has evolved from commodity money to metal money to paper money and then to legal tender. Mm-hmm. So if you put money here without further explanation or definition, it's quite vague. And it can encompass gold, because gold is also a medium of exchange and means of payment. So if an institution is taking deposits, which is in the form of gold, in effect, this act affects it.
Okay.
So it is not vague at all. It is very clear that the central bank and then the SEC have a responsibility, to regulate such an institution. But that does not in any way actually put a liability on them for bailing these victims out. And so going forward, I think we need to streamline our framework. We need to strengthen our institutions to making sure that the wording and everything else is clear. It covers all activities, all financial activities, so that we will not be in the middle and not knowing whether we should come in or not to come in, and be more proactive.
Right. I'm taking a break at this point, and then when we return, we'll deal with the Bank of Ghana cleanup and the matters arising. But I asked the question, how clean was the cleanup and what is next? But before I do that, there's one other issue that our viewers and listeners want Ace to speak to for them. He's been doing a lot of free legal advice. Of course, he's been doing that for so many years. So they have asked questions about the associations that, celebrities have done, endorsements. For some of them, these are the things that entice them to put their money in Menzgold. Some say because they saw him in a photograph, in a handshake with the president, they saw him, in a private jet, giving red carpet treatment at Menshia, among others. He together with the chief imam, and then the celebrities, almost name them. Your favorite celebrities in Ghana endorsed him. So they're asking, is it really the case that they can't have any cause of action against the celebrities?
Samson, being a humble panelist in your station, if at the end of this program I beg you for a picture and we take one outside and I float it on social media, then that becomes an assurance that I have access to your bank statements and your bank accounts. Really? It's a desperate and rather silly argument. Yes, in terms of dropping hints, and it is the normal style of the Ponzi people. They must show a certain lifestyle. Now, I'm sorry, but if the bank manager of my bank or the owner of my bank, I see him in a private jet, my money is leaving the bank tomorrow. It will not move me because I know how much it costs to rent a private jet. And I know that he cannot afford that, but for the fact that he's overpaying himself. And so the next day, now, if I see that kind of cars parked in his house, my money is out. You cannot say that because you saw the cars parked in his house, you gave him more money. Now, it is the opposite. It should be the opposite reaction. You should ask yourself, where is he getting all the money from? It's from you and I. And so to say that you've seen a nicely cropped picture of him with the president, so you took your money there. Is that the level of investigation before you take 500,000 cedis to somebody? Is that your level of investigation, that he took a picture with the chief imam, or that he went to Kumasi and on a jet and there was red carpet and people dancing? Now wait, red carpet is paid for. Dancers are paid for. The plane is paid for. The pilot is paid for. There are hangar charges that are very steep. There's aviation fuel. And so you should ask yourself, where is he getting all of this money from? It is my money that is feeding his lifestyle. That is why I have a basic definition of Ponzi. That a Ponzi scheme is where fraud is milking greed or naivety. Fraud is milking greed or naivety. So my view is that those pictures should rather have made you more cautious that your monies were being blown. He's on a plane and they are playing music and he's dancing with his friends and he's wearing gloves while sitting on the plane. For crying out loud, guys, how can this mislead you? Anybody who says that is saying, here, I'm a dummy, shoot me. No. So you have no cause of action against them.
During all this, in terms of tax.
Well, now the question is this: did they even file a new tax return? Yes. They have not had access to the books. The people went to court, so everybody froze. I don't think that the December court action should have frozen authorities because there was no application for interlocutory injunction. So they could have moved into the books. They don't have the books. Did they ever pay tax? We don't know. Did they even have bank accounts? We don't know. As we sit, we are flying blind. It is only now that SEC is going to break those doors and hopefully find some documents.
All right. Thank you very much. We'll take a break here. This is Newsfile. It's your most authoritative news analysis platform. We'll be back to ask questions about the bank cleanup and how clean it's been.